So hello everyone, welcome to our monthly InfoSec seminar. Today we are very pleased to have NG and Christine to give us an interesting talk about the role of the Office of the Information and the Privacy Commissioner, OIPC of Alberta. NG has been a member of the Compliance and the Special Investigations team since April 2014 when he joined the OIPC. In addition to conducting offense investigations, he advises the OIPC on information security matters. Prior to his role with the OIPC, he worked at Alberta Health, where he helped lead the development and implementation of Alberta Netcare Provincial Organizational Readiness Assessment and the Provincial Logging and Auditing Standard. He also worked at Alberta Health Services Governance, Risk and Compliance, and the Information Privacy teams, advising business areas and the project teams on IT security and information privacy. NG has attended a Master of Science in Physics, a Master of Information Systems Security, a Bachelor of Science in Physics and Computer Science. He also has CISSP and CDBSE certifications. Christine joined the OIPC in April 2017, where she works on the Compliance and Special Investigations team. Currently, her focus is on conducting privacy investigations such as offense investigations. Christine has a wealth of experience in public sector and health sector privacy and information security. She has worked for the Faculty of Medicine and Dentistry at the University of Alberta, Alberta Health Services, Alberta Cancer Board, Alberta Health and Alberta Children's Services. Her educational background includes a Master of Information and System Security Management and certifications in Information System Security Privacy and Auditing, CISSP, CDBSE, and CISA. Thanks, NG and Christine, for accepting our invitation and joining us today, and we are proud of you as you are MESAM alumni. So please go ahead.
Thank you so much, Dr. Abdullah. During this presentation, we will tell our audience about the role of the Office of the Information and Privacy Commissioner. We will also try to connect the job that we do in relation to what we studied at Concordia. So there are two aspects to this. There's the privacy aspect to it, and there's also the information security aspect to it. And we also, try to demonstrate how important having a security background makes us do our work more efficiently and a lot faster. So on that note, I will tell you about the agenda for today, and we will discuss the OIPC organizational structure. We'll talk about the privacy laws in Alberta. We'll talk about the roles of the OIPC in enforcing those privacy laws. We'll talk about some of the key things that we do in the office, the privacy impact assessments, and we'll talk about privacy breaches and how they relate to security incidents. We'll talk about some of the investigations that Christina and I are engaged in the office. Those are one of the some of the most exciting part of what we do. And we can also discuss some challenges that we face as we do those investigations. And we'll talk about other types of investigations that occur in the office. So we have divided the presentation in two parts. Christine will take the first part of it, but I will jump in from time to time if I have additional thing to add after she's done. And when I start talking, she can also chime in once in a while when she has something to add. So with that much about, with that introduction, I will let Christine take over the conversation going forward.
All right, thank you, NG. So a little bit about our office. The head of our office is the Information and Privacy Commissioner, who is Jill Clayton, and she's an officer of the legislature. She's independent of the government of the day, and she reports to an all-party member standing committee of the Legislative Assembly. The end of her mandate is coming up. It's the end of January 2022. She's served 2 5-year terms, and she's not seeking re-election.
So if there's anybody that wants to be the privacy commissioner, now is the time.
So our vision is to have a society that values and respects access to information and personal privacy. And our mission is to advocate for the access and privacy rights of Albertans and to ensure public bodies, health custodians, and private sector organizations uphold the access and privacy rights contained in the laws of Alberta. We try to provide fair, independent, and impartial reviews in a timely and efficient manner. So our office is divided into about 5 different sections. So there's the Strategic Initiatives and Knowledge Management Group, and that consists of our intake staff, IT, and records management staff. Then we have Compliance and Government Relations, and that's where NG and I fit. We're on the Compliance and Special Investigations team. And there's also the Mediation and Investigation team. So a little bit about our section, we do the privacy impact assessment reviews, we investigate or review the privacy breach reports, we conduct investigations. And then the mediation and investigation group, they review a lot of the complaints that come into our office and the requests for reviews regarding access requests. Then there's the adjudication group, legal services, and then we have a special projects and investigations.
Just to add on the legal services is an internal team that advises the commissioner in regards to legal matters, because sometimes the commissioner might issue or the commissioner issues an order and the order has the same power as an order issued by the court. And public bodies or custodians or organizations have the right to challenge those orders in court. And when that goes to court, then the legal services provide advice to the commissioner on things like that. And also on contract basis. If we need to hire somebody from an IT standpoint, then contracts need to be drafted and we get advice from the legal services. So Dr. Abdullah, we didn't talk about this part before we start the presentation. I'm supposing here that all questions will be, or you will track questions, and then at the end of the presentation, we can just answer those questions.
Yes, sure.
Thank you.
All right. So in Alberta, we have 3 privacy laws. We have the Health Information Act, which is referred to as HIA a lot of the times. And this act applies to custodians and health information. So what is a custodian? Well, it's defined in the Act and the regulations. And some examples are physicians, dentists, pharmacists, and then Alberta Health Services and Alberta Health. If you want a full list, check out the Act. There's quite a few, but you'll be shocked maybe that there aren't some of the healthcare providers like physiotherapists and, certain people that provide health services aren't actually covered under the Health Information Act. So it's important to take a look. Then there's the Freedom of Information and Protection of Privacy Act, or FOIP. And this applies to public bodies and personal information. So it applies to the government of Alberta's ministries, universities, schools, school boards, municipalities, the police, our office. Then there's the Personal Information Protection Act, or PIPA. So this applies to organizations and personal information, such as Save on Foods, Staples, Best Buy, Home Depot. So PIPA applies to the private sector, organizations that operate in Alberta and provide services to Albertans. And you might have heard of the Act PIPEDA or PIPEDA. Well, in Alberta, we have PIPA, which was deemed substantially similar to PIPEDA. Therefore, PIPEDA is generally the act that would apply to Albertans' information collected in the private sector.
Just to add to what Christina just mentioned, another concept that we need to keep in mind is the concept of custody and control. The health information we are talking about, the personal information we are talking about, needs to be in the custody and or control of a custodian for HIA to apply, or custody and or control of an organization of public body for PIPA and FOIP to apply respectively. So the concept of custody and control is very important when we look at the privacy laws.
So the roles of the OIPC, some examples are we oversee and enforce the administration of the acts to ensure the purposes are achieved. We resolve access and privacy matters through mediation, investigation, and if that doesn't work, adjudication. The commissioner has order-making powers and can order compliance to any of the provisions of the 3 acts. Our office reviews and comments on privacy impact assessments, and we review breach reports that are submitted to our office. We give access and privacy advice and recommendations to custodians, public bodies, organizations, and just the general public. We also have an education mandate. We inform the public about the act and receive their comments. Angie, did you have anything to add? Is he frozen?
Yes.
Okay, next slide if you don't have anything.
Oh, okay. All right. I wasn't sure what was going on. Okay. Just to add, and you're not satisfied with the outcome of my investigation, you can make a for that investigation to go to inquiry, and that inquiry is handled by complaint, and in some cases they may uphold my outcome, and in other cases they may have it.
Okay, so privacy impact assessments, or PIAs. So a PIA is basically a risk assessment that looks at how information is protected and assesses how the information flows related to the system or the practice complies with privacy legislation. They're a proactive approach to protect personal and or health information, which hopefully will prevent breaches from occurring. Many system developers are using privacy by design principles, so should already have controls in place to support privacy law compliance. However, not all systems will have adequate privacy and security safeguards. So before choosing a system to implement, consider reviewing the PIA requirements so you can pick one that will be compliant with Alberta's privacy legislation, because it's a lot harder to add controls after you've implemented something than just pick something that will have it in the first place. So you may be interested to know that PIAs are only mandatory for custodians under the Health Information Act. So public bodies under FOIP and organizations under PIPA are not required to submit PIAs, although it is great when they do submit these because it shows transparency and an effort to comply with the laws. And it will show us that they have reasonable privacy and security safeguards. So a lot of times they will submit those to our office so they could demonstrate maybe to their stakeholders or to the public that they have done their due diligence with respect to privacy and security. The Health Information Act, Section 64, so this is the section that mandates privacy impact assessment, states that each custodian must prepare a PIA that describes how proposed administrative practices and information systems relating to the collection, use, and disclosure of individually identifying health information may affect the privacy of the individual who is the subject of the information. And this must be submitted to our office before implementing the system or the practice and before making any change to an existing system or practice. So examples of when a PIA needs to be done would be if you're planning on collecting, using, or disclosing information that you didn't before, if you're implementing a new system or a new technology or a new service delivery model, if you're hiring a new contractor, changing vendors, or starting to do some data matching that isn't covered by a research agreement and the research controls. So, Angie, did you want to jump in with anything before I talk about our process?
Yes, the only thing I needed to add here is that privacy impact assessment is one of the major things that we do in our office. It gives the commissioner and the staff, or it gives the Office of the Information and Privacy Commissioner an opportunity to modify system implementation or implementation of administrative practices to ensure compliance with privacy and security controls. I will also make an analogy here that in the security world where identifying information is not involved, for instance, from time to time it's recommended that you get an independent third party to do a security review, maybe a vulnerability assessment or a penetration testing, and give an assessment so you can fix issues. A privacy impact assessment is an opportunity for the OIPC as a third party to look into the implementation of your administrative practices and maybe provide recommendations, or maybe say that, hey, you did a good job, or these are areas you might want to consider for improvement in the future.
Perfect. So when we receive a PIA, the PIA will be assigned for review. And then one of us, senior information privacy managers, will get the file. We'll review the submission, and then we may ask questions. So eventually the goal is to accept the PIA. However, not all PIAs are accepted. We get a significant amount of PIAs submitted to our office every year. As you can see from this slide, over the years, it just keeps going up and up. There were 1,363 PIAs accepted by the office last fiscal year. This was a 32% increase from last fiscal year. There was a 31% increase of opened PIA files from the previous year, and a 42% increase of closed PIA files from the previous year. So we're getting more in, and we're trying to keep up and close them, and most of them are accepted. So when looking at the accepted PIAs, nearly all of them were Health Information Act PIAs. So 98% were under the Health Information Act, submitted by health custodians.
By acceptance of a PIA, I need to differentiate acceptance and approval. So we do not approve PIAs in our office. We accept a PIA. If I accept a PIA, I am saying that it is my opinion that you've considered the protection required for personal information, and that I think you have implemented reasonable controls to protect the information that the PIA is for. So this is what we do. And sometimes we accept PIA on the condition that you fix certain things. Sometimes we accept PIA making a recommendation that you do certain things. So a PIA that is accepted on conditions means you have to fix those conditions for that acceptance to hold. But when it's made on recommendation, it's a whole different matter. You may recommend it, you may fix the recommendations or not. When it's recommended, it means the risks are low, but when it's on condition, it means that we found something significant that you need to fix.
And then in some cases, we just can't accept it because the risk is just too high.
That is correct.
So what is in a privacy impact assessment? What does it look like? Well, if you're ever in a position that you need to write one, please take a look at the URL, which is our PIA requirements document, and it will give you a thorough overview of what needs to be included. But I wanted to give you a quick overview. So there'll be the cover letter, cover page, and then these 5 main sections. So there'll be the project overview, describing what this project, like the system or the administrative practice, what it's all about, what's the purpose for it, that type of thing. Then we'll want to know about your privacy management at your clinic or your place of business. So describing all your privacy training, your privacy policies, how you're managing privacy at your place of work. Then Section C is a huge component of the PIA, and that's the privacy analysis. So that's where we're looking for what data elements are involved, what's the information flow, what are the legal authorities, what does the law allow you to do with that information. So that part is very important. And then Section D is where a lot of the IT security controls are. This is the privacy risk mitigation section. So it's required in the PIA to have an access roles table, for example, a risk assessment table. And there's some other sections too, like monitoring and audit logs, that type of thing. And then Section E is where we will expect all the privacy policies from your organization to be attached, and any specific project-related policies and procedures as well. So depending on the environment, PIAs may be completed by a group of individuals or maybe just one person. If you're lucky, you'll have a group of people that are all working together to complete this PIA document. And you'll want someone probably with a legal or privacy background. An IT security person would be really important. And of course, you'll need the business lead or the person making the decisions under the Health Information Act, the custodian. So it's important to know that privacy doesn't work in silos, and understanding the implementation of the controls in place to protect information and privacy is a key piece. So being able to leverage IT security professionals will really help a PIA writer describe the technical safeguards in Section D, such as encryption algorithms, access controls, including authentication methods and secure storage of credential information, audit logs, auditing processes, all those pieces that a lot of people, say on the business side, may not understand. These technical controls are a huge part of the PIA, and submitting it without that information will be incomplete and will cause us to ask you a lot of questions and a lot of back and forth. Angie, did you have anything to add?
Yeah, the only thing I wanted to add here is that in the concept of privacy, when we talk about privacy, something we didn't mention earlier is that if there's no identifying information, that concept doesn't apply. Then we just deal with the security aspect of the information. Once there's identifying information, identifying a person, then that concept of privacy comes in. And generally speaking, when it comes to PIA, there is the technical aspect of it, and there's the governance aspect of it. If you have good technical controls in place, and then you have weak governance, it's highly unlikely that we will accept your PIA. If you have good governance with weak controls, it's not going to happen either. So we try to strike a balance, and we're not looking for perfect controls. We're looking for reasonable controls.
Yes. And, we do see PIAs that are systems or practices that deal with de-identified information, and the custodians or the public bodies will still provide it to us because there is still maybe a risk of being able to re-identify information. So, PIAs are still important, I would say, for a lot of types of information.
And we encourage custodians and organization and public body, if you are not sure, just contact our office.
Yes. All right. So
am I too fast?
You probably heard about the AB Trace Together PIA, or the app at least, that the Alberta government put out last year to assist them with their contact tracing. It was implemented near the beginning of the pandemic, and members of the public could download this on their cell phones to help see if maybe they were close to someone who had a positive COVID diagnosis. So before this app was released out for the public's use, Alberta Health submitted a PIA to our office, and it was endorsed by Alberta Health Services. Our office reviewed the PIA, and we ended up publishing a report highlighting that the app's purpose was to supplement the already established contact tracing processes, Alberta Health's consent-based approach to ensure clear agreement by the individual to participate, limited collection of health and personal information when registering to use the app, and efforts to reduce the risk of secondary use of information collected by the app. Specifically, there were concerns about quarantine enforcement at that time. So we also identified some issues in the report and made some recommendations. And I won't get into all the details. It's a really long report, and I provide the URL here so you could take a look if you're interested. But we wanted to highlight this because this was the first time that our office published a report on a PIA review. And the reason we did this was because we felt it was important to let Albertans know that our office did review the app and the related processes to look for privacy law compliance, and to ensure that the privacy of Albertans were taken into consideration as we were all going through the pandemic. Andy, did you want to add to that?
I think the only thing I would like to say here is that we wanted to make sure that even though we were all struggling to cope with the pandemic and finding ways to deal with the pandemic, the privacy rights of Albertans were not getting neglected. They were also at the forefront of everything that the government was trying to do, and we were there to provide feedback when needed.
So I wanted to highlight some of the items from the specific PIA that had a technical or IT security focus, and emphasize again how helpful it is to have people with IT security backgrounds participating in the writing of PIAs and even help review them, have people like you guys in our office, because as you can see, there's a lot of technical and IT security items on this slide, and this is just a sample. So this is just one PIA. As you saw from the other slide, we see a lot of PIAs in our office, and there's just endless options as far as new systems and apps. And, you know, even when we see two different groups using the same app, they usually have different options enabled. They're implementing them differently. So there's so many different risks that we have to look at. And it's really great to have an IT security background. Having this background allows us, like Angie and I with this background, to look at these PIAs, identify the risks quickly, see where mitigation is not quite met in a reasonable manner, and highlight them to the custodians or to the public bodies. And we don't have to consult with external people or other people on our team usually, because we have that background. So
based on what Christine is saying, it looks like we're the cool kids on the block. You know what I'm saying?
Wonderful. Okay, well, I'll pass it over to you, Angie, on breaches.
Thank you very much, Christine. That was lovely. So I will just transition to talking about privacy breaches. And before I do that, I will want to first talk about security incidents. And usually when we talk about information security incident, we talk about things that impact CIA, confidentiality, integrity, and availability. And I thought if you talk about this, then you can build on that when you talk about privacy breaches. So it just kind of shows what Christine said earlier, that information privacy doesn't exist in silo. It has to be in connection with information security. So they are related. So speaking about that, unauthorized access, modification, or loss of information is information security when there's no identifying information involved. But once we step into the world where there's a mixture of identifying and non-identifying information, then we talk about privacy breach. And we talk about privacy breach in the context of the law as well as in the context of CIA. So if there's an unauthorized collection of somebody's identifying information, access, use, modification, disclosure of that information, then that's a privacy breach. And that is based on what the law is about. If you lose information of somebody, that's a privacy breach. The reason somebody might say, oh, why is that a privacy breach? We know that under the law, I have the access to request for my information in the custody or control of a public body, a custodian, or a private organization. But if you lose that information and you deprive me from making that request, then that's where we'll have a problem. That's where the aspect of privacy breach comes in. So under the different laws, we have different requirements for privacy breach. There's generally what we call the privacy breach notification requirement. And some of those requirements are engraved in the laws, like PIPA and HIA. They have specific requirements for notification. So if there's a risk of significant harm to the affected individual under PIPA, that breach must be, the commissioner must be notified of that privacy breach. And the individual who is the subject of the information must be notified of the privacy breach. Under HIA, the language is a little bit different. It's more of a risk of harm. So the risk of harm may be a lower threshold compared to a risk of significant harm. So it's more generic under HIA than under PIPA. There could be a risk of harm under PIPA, but if it's not significant, then that notification requirement may not be needed. Notification to affected individual is an important aspect of managing privacy breaches, because if my information is lost or compromised, you would like to tell me so that I can take steps to prevent the misuse of that information. So it is very important that once that happens, it should be considered as part of managing the privacy breach. Of course, you cannot take away the fact that the breach has happened, but you can do something to make sure that the affected individuals are not impacted further. And again, we shouldn't forget that they are the victims when that happened. Under FOIP, Freedom of Information and Protection of Privacy Act, there's no notification requirements. However, the commissioner has said time and again that it is recommended that public bodies report privacy breaches to our office, so we can help them. We can work with them to make sure that this doesn't happen again in the future, or that they are properly managed. So looking at what we've seen so far in the last fiscal year, which is found in our annual report on our website, between April 1st, 2020 to March 31st, 2021, we had 377 people reported breaches to our office, and Health Information Act, there were 930. FOIP, there were 81. And the main reason is because it's not required. So these are voluntary notification under FOIP. And affected individual under FOIP, the law doesn't require them to be notified, which is unfortunate. Now, let's look at some of the common causes of privacy breaches. What we see so far, many times in our office, system compromises through social engineering, ransomware, hacking, malware, and sometimes it's based on system implementation, because the system were not configured properly, or because they had weaknesses and they were not addressed, and then the bad guys exploit the weaknesses and get into the system. And we see snooping too. Snooping is a case where people just, because they have access to information system, they do access that the information without a need to know, without a business requirement. And it's a huge, huge aspect in the health information industry. In the health information in the health sector, we see a lot of snooping, some of which end up being investigated by the commissioner and into prosecution, that as we're going to see a little bit later in the presentation. Another thing is human error. Facts get misdirected, emails get forwarded to the wrong people with identifying information on it. Exfiltration. This happens when somebody compromises your system and they steal information from your system. Sometimes you got rogue employees that steal information from your system. So we see all these various causes of privacy breaches in our office. Christine, anything?
Yeah, I just wanted to add a couple other ones. We're also seeing a lot of disclosures on social media and attacks on third-party service providers.
That's right. Sometimes it's difficult to go after the organization. Say I want to go after Concordia, which I wouldn't do, just so you know. I may decide to go after a company that works with Concordia. So when I compromise that company, then I can pass through that company to get access to Concordia's network. So you see some of those things. Let's talk about some of the investigations that we do in our office. And we usually term them investigations initiated by the commissioner. And one of them is the offense investigation. It is a key component of what Christine and I do. Within the compliance and special investigation team, we have a sub-team called offense investigation team. It's comprised of 3 people, myself, Christine, and one of our colleagues that is not here today. And the commissioner has powers under the 3 legislation to initiate offense investigation, and that goes to prosecution if the Crown recommends that charges be laid. So these are the different sections. Section 107 of the HIA, and FOIP is section 92, sub 1, and PIPA is section 959, sub 1. And how do we get into an offense investigation? Usually, it's as a result of a privacy breach being reported to our office, or somebody makes a complaint about the unauthorized collection, use, or disclosure of his or her health information. And we review those reports, and the commissioner might say, hey, this may meet the threshold for an offense investigation. So let's look at an example of what happens when we get one of those. Say unauthorized access to health information under section 107 2A of the Health Information Act. And that section says, no person shall knowingly gain or attempt to gain access to health information in contravention of this act. So the key aspect here is knowingly. It is important that we prove that the person did gain access, but the person did that knowingly. If we prove that the person did get access, but we could not prove the knowingly part, it's not going to stick. So this is what this is some of the challenges that we face in our job. We don't just look at the information security aspect of what may have happened. We look at the legal and the privacy aspect of what happened. So to combine those two together sometimes make things a little very tricky for us. And everything we need to do has to be within the limit of the law. If we go beyond that or deviate away from that, we may just end up, the case may end up being tossed out. The standard of proof for offenses that we do is proof beyond reasonable doubt. So it's a very high standard. It's not even within the limit of probability. No, this is proof beyond reasonable doubt. And it is also important that in the course of the investigation, we maintain chain of custody of evidence, because if we're going to present this in court, we need to make sure that that evidence is deemed reliable. Otherwise, we have issues. Christine, anything to add?
No, I'm just cautious about time.
That's correct.
So, yeah.
Okay. So some of the key evidence that we use when we have a report that somebody accessed health information, for instance, contrary to the Health Information Act, are audit logs. As we said earlier, this is when information security, the importance of information security comes into play. And this is when doing a privacy impact assessment comes into play. One thing that we didn't tell you earlier, if you submit a PIA for a system you implement and it doesn't have audit logs in it, we will not accept it, because it's one of the key security features for investigating privacy breaches. The audit logs should have specific components of what we will require in the event that there's a privacy breach. So an audit logs will tell us when somebody accessed health information, who accessed it, what account it was used. But then we also need to determine the security practices. If you say that you have a unique user ID and password, as we know, that is related to the audit logs, that is fine. But then if you tell us that there's a widespread practices where people were sharing user ID and password, then that throws a lot of question, because I will not be able to say that it was Christine that accessed this information, because the practice is we share password. So you can't say this is my account. Christine may have used somebody's account to access it, or somebody may have used Christine's account to access that information. So in that case, I don't want Christine to be punished for something she didn't do. I cannot even prove that it was Christine in that case. But if we get past all those things and we are able to establish that the practice is unique user ID and password, then I can say, yeah, this lot belongs to Christine. But then I need to find out if Christine did that knowingly. How do you know about something is not right? If they provide you with training. If the custodian failed to provide you with the training, and again, it's not just any training, the right training that tells you that you're not supposed to do this. And as part of the witnesses, as part of the collection of evidence, we interview witnesses. If the person of interest said this was a practice, we interview the colleagues at work and say, hey, this is what happened. What do you know about? What kind of training did you get? And then we ask the custodian, can you provide a record of the training that this person did? And based on that, we are able to determine that this person knowingly accessed health information contrary to the Health Information Act. And when we do witness interviews, we record the interviews. It is our standard practice too, but we just tell the person being interviewed that this is going to be recorded. And then the recording gets transcribed, and then the transcript gets included in the investigation report. Another key thing that we take into consideration is to make sure that the person of interest that is under investigation is informed of his or her charter right, the right to silence. We need to tell that person that he or she has the right to silence. If we don't do that, the evidence we collect under that circumstances is thrown away, is inadmissible in court. And to tell that person is one thing. We also need to find out from that person that whether that person wants to contact a lawyer. If that person said, I will need to contact a lawyer, then we stop there. We say, okay, talk to your lawyer. When you're ready, you come back to us. Or we will contact you in a week or two to find out if you still want to talk to us. Sometimes they talk to their lawyer and say, no, I don't want to talk. That's fine. That's their right. But that doesn't mean that we stop our investigation. We keep doing. Sometimes they talk to their lawyer and they still come back and talk to us. Sometimes they show up with their lawyers. We say, fine and good. Sometimes they don't have a lawyer and I say, can I bring my dad? I say, sure, bring your dad. The important thing is that you tell me what I need to know. Christine, any addition?
Nope.
Thank you. So once we collect the evidence, we write a report about the investigation. And then we meet with the commissioner and say, Commissioner, this is what we found. We found that there's enough evidence that proves beyond reasonable doubt that an offense was committed. And the commissioner said, okay, if that is what your evidence says, then I'm going to refer the case to the Crown. The commissioner refers the case to the Crown. If that is the case, if there's no sufficient evidence, and the commissioner may say, okay, is there a way by which we can educate the public in regards to what happened here? Can we make some recommendations? And then we make recommendations, and then that case is closed. But once it goes to the Crown may say, okay, I'm recommending charges, or I will not recommend charges. Sometimes the Crown say it is not in the public interest to prosecute this case, so charges are not recommended. But once charges are recommended, Christine and I will make sure that those charges get laid, because we are the office laying those charges, not the Crown. But another challenge we face is that charges must be laid within 2 years that the commissioner was made known of the offense or alleged offense, let's put it that way. So once 2 years has passed, prosecution cannot take place. So it's one of the challenges that we face, and we need to make sure that we keep that time frame in mind. And once charges get laid, then it goes through the court system. Sometimes people, the persons of interest plead guilty, and then the case get resolved faster, or the person of interest may decide not to plead guilty, and then it has to go to trial. And once it's completed, nobody goes to jail when it comes to our offenses. What you can get is a fine, you can get a probation order, you can get a community service, you can get a ban. We've got few cases where the judge bans people from accessing health information for 1, 2, 3 years, or a combination of all this. So at this point in time, we have 6 cases before the court, and we still have more that we are working on at this going forward.
I just wanted to say that, as you could see from NG's stats on the previous slide, we get a lot of breach reports in our office, and we're only conducting offense investigations on a very small amount, the more egregious files, and those are the public interest.
Thank you, Christine. And some of the fines that are stipulated in the 3 privacy laws about offenses are on the screen here. So the Health Information Act was amended last year towards, I think it was December last year, and the fine went up. So right now, if an individual like you and I, we could be fined up to $200,000. Any other person that could be a custodian or something, maybe up to $1 million. The fines under FOIP, it looks like a joke to me, but that's the law. Except in the case of a public body, it may get fined up to $500,000. PIPA is 10 grand for an individual and $100,000 for an organization, which is because PIPA has not been updated for quite some time. So it's not catching up. If you compare the fine that people get under the GDP global, Christine, what is that law again in Europe?
GDPR?
Yeah, it's a lot heavier than what we get here. So we still need to catch up with the rest of the world in regards to offenses, privacy offenses. And for the interest of time, these are some of the offenses that we've gotten so far or that we've completed in our office. We started since April 2007. I think the highest we've gotten was 15 grand. And then there was a $10,000. And then we have a number of them, 5,000 plus 2 years probation, 6,000 plus you cannot access health information for 2 years, which means if you are a nurse, for instance, that means you can't work in nursing field for 2 years if they say you can't access health information. So that's basically what it means. We have about 18 convictions so far. All of them are under Health Information Act. We had a case under the FOIP Act that went to the Crown, but the charges were not recommended because it kind of involved children in care. I think the Crown said it was not in the public interest. And then case number 16 and 17, Christine worked on those. So we don't have news released on that because there was a publication banned. It involved a small community whereby if you publish that information, the community might just explode because everybody knows everybody. So in that case, the judge said there should be no publication.
And NG had a file that involved a criminal charge as well.
That's right. So there was a case where health information was modified in a lab system. So even though we did that under the Health Information Act, the Crown looked at it and said, no, we're going to charge this person criminally because it falls under another law in Alberta or Canada. And they did that. And in that case, that person had a criminal record. But in our cases, when it's a fine, you don't get a criminal record. Other types of investigation that we do in our office is what we call special investigation. Like you have the Arcana investigation, Babylon investigation that was in the news, and then Clearview AI, artificial intelligence, and Life Labs. We have links to all these things, so you can take a look. There are a lot of things that go on in the office, and they demand different level of skill set, but generally, it's a fun place to work, because we're never bored. So we can take questions, I suppose.
Thank you so much. Thank you so much, Angie and Christine, for this very interesting talk. So please, do we have any questions? Any questions? Maybe. So I have one personally. So does each province have its own office of information and the privacy commissioner?
Christine, you want to take that?
Sure. Yes, all the provinces and territories have privacy commissioner offices, but the powers are quite different in the different jurisdictions, and the laws can be quite different. So it's kind of a patchwork of privacy laws, and like Alberta's one of, I'm not even sure how many provinces have the order making powers, but I know Alberta was the only one at first, but I think there's a couple or a few, but definitely not all the provinces and territories have, say, that power. Some more are ombudsmen and just providing more guidance, that type of thing.
Yeah, so yeah, you're absolutely right, Christine. The powers are different and the names are different. We call them OIPC, Office of the Information and Privacy Commissioner. In some provinces, they just call them ombudsman. And then they do a number of things. And sometimes you have a split between the Information Commissioner and the Privacy Commissioner. And then in terms of the order making powers, even the Federal Privacy Commissioner didn't even have that before. So I think Alberta was leading the race in terms of that kind of powers.
So just to follow up, like what happens if you have a case that includes more than one province?
If that happens, then we work with our counterpart in that province to resolve the case. We've done joint investigation with BC, for instance, joint investigation with BC, the Federal Commissioner, and our office. So we usually work together.
Great. So Elizabeth, please go ahead.
Hi guys. Hi Angie, Christine. Thank you for the presentation. Awesome presentation there. My question, recently Manitoba did had problem with their healthcare where there was a breach in information and the whole information was accessed. If that were to happen in Alberta, do you mean that the stakeholders or the people involved will not be informed? Because I think one of your presentation, you said when it comes to healthcare and for some certain kind of breach, then people don't necessarily have to be informed. I'm just trying to clarify how that works.
Yes, that was in the FOIP, the Freedom of Information and Protection of Privacy Act. We said that there's no requirement within the law to notify people or even the privacy commissioner if a breach happens. But usually when there's in the province, based on what I've seen so far in the office, when there's a breach, that is a high-stake privacy breach, put it that way. People become very proactive to notify the privacy commissioner. But if we hear through the media, sometimes we get contacted by employees of that public body or by the media, and then the commissioner can launch an investigation into that. And in some cases, may demand that the people be notified. Christine, does that sound?
Yeah, so FOIP applies to public bodies in a health situation. They would fall under the Health Information Act, and Luckily, there are those mandatory breach notification provisions. So you should be notified if you're in Alberta and it was a health care related breach.
Yeah, and our office have been working with the Minister of Service Alberta in regards to updating some of the old privacy laws in Alberta.
Thank you, guys.
Any more questions? Any more questions? So,
and I also like to add that if for some reason, if people think about questions later on, you can always channel that to us, and we'll be very delighted to respond to them.
Great. Like Nijaya and Christine, could you please stay for a few minutes after I close the presentation?
Yes, of course. And one thing I need to tell my fellow students at Concordia, I was just like you some years ago, and if I can make it, I think you can make it a lot better than I am, because I was not the smartest student in the course. So what you learn there is really, really, really important. It's a piece of tool for you to succeed outside here in the Y. If I'm able to succeed, I think, and I'm using exactly the same set of tools, oh, you're good. You're definitely good.
Okay, so thanks again, Angie and Christine, for your interesting talk and all this useful information. And thanks everyone for joining us today. We wish you all happy holidays and happy new year. We will see you on the next seminar on January 13, 2022.
Thank you so much for having us.
It was a pleasure. It was a pleasure indeed.
Thank you very much. Bye.
Bye.